If your 601A waiver or 601 extreme hardship waiver looks like this and just says, I will miss my husband, or I will be sad if my husband is deported, USCIS will deny your case. You want to know why? Because winning an extreme hardship waiver looks like this. It's a thick binder, okay? This is what we're going to be talking about today. I am pulling back the curtain on exactly what USCIS considers extreme hardship and the 3 types of undeniable evidence that your family must gather in order to give yourself a leg up on the extreme hardship waiver. When it comes to the extreme hardship waiver, whether you're applying for a 601 waiver or a 601A waiver, you still have to prove extreme hardship. So when it comes to those waivers, you want to make sure that the hardship that you are focused on is the hardship to the qualifying relative, not to the immigrant. This is one of the biggest misconceptions people have, is that they will file a 601A waiver and all the hardship is for the immigrant, not the qualifying relative. That's number one. You want to make sure that the hardship you are zooming in on is on the qualifying relative. And if you're wondering what a qualifying relative is, for an extreme hardship waiver, the only qualifying relatives are the spouse or parent of that applicant that is either a U.S. citizen or a permanent resident. So if you do not have a qualifying relative, you would not qualify to even apply for this waiver. Once you have your qualifying relative, now you want to make sure that you can prove that they will suffer extreme hardship in 2 scenarios. And you can prove one or both of this. I like going for both because when you go for both, you give yourself more chances of USCIS approving your waiver. The first scenario is what happens to the qualifying relative if the applicant leaves the U.S. and the qualifying relative stays in the U.S. The second scenario is what happens if the applicant leaves the U.S. and the qualifying relative leaves with them. Now, in both scenarios, you want to focus in on what is that hardship that the qualifying relative will face if they stay in the U.S. without their family member, or if they leave the U.S. with that family member. What is the hardship that they will face over there? Again, the most important thing here that I want you to zoom in on is the hardship to the qualifying relative, no one else, okay? Hardship to the qualifying relative. Like I said at the beginning, there are 3 categories of evidence you want to gather if you are in this situation. The first category is medical and psychological. This is where you lay out what are the medical conditions that the qualifying relative has and how does the applicant's presence in the U.S. help with those medical conditions. What would happen if that applicant leaves the U.S. and the qualifying relative stays in the U.S. and is managing their medical condition on their own? Remember, I said there's 2 scenarios you want to show. Now, you also want to consider and provide evidence of what would happen if the qualifying relative with those medical conditions had to leave the U.S. with their applicant family member and live in a different country. Will they get the same level of medical treatment? Is there evidence that the medical condition that they have cannot be treated in the country where the applicant is from? This is the gold when it comes to the medical psychological category. If the qualifying relative has a specialized medical condition that requires certain treatment that can only be received in the U.S., and the qualifying relative, if they had to leave the U.S. with the applicant, will not get the same medical treatment, this is what we call gold. Because if we can show that the country that the applicant is from does not have the resources, the medical facilities to actually make sure that the qualifying relative can get the medical treatment they need, this is amazing for your 601A or 601 extreme hardship waiver. It is important to know that just saying that, oh, I'm so anxious about my family member being out of the US, and saying, oh, I have anxiety, a self-diagnosed medical condition does not count in this situation. Okay, so if you do not have a mental health diagnosis, you cannot expect USCIS to just believe you. So what can you do to have documented evidence of that medical condition, mental health medical condition? If you have an ongoing therapist that is already treating you and knows all your medical conditions, has diagnosed you with different medical conditions, then you can use a report from that therapist. But if you do not already have that, one thing you can do and should do is look into doing a psychological evaluation by a licensed specialist. This is very important because a psychological evaluation is the therapist or the psychologist meeting with you, getting information about your life, giving you a diagnosis if there is one to give. And now you have documented evidence of your anxiety and the level of your anxiety, the level of your depression. So just saying, I will be sad if my husband is deported. Yes, everyone would be sad if their husband is deported, right? But what about you, the qualifying relative, makes this extreme, right? Do you have severe depression? Do you have PTSD? Do you have separation anxiety tied to an incident that happened while you were younger that you have still not gotten over, right? Now you want to tie all of those things in together, but you can't do that because you're not a licensed professional. So you want to make sure that you are either getting diagnosed by your regular therapist or you're doing a psychological evaluation. This is very important to straighten your case. A 601 or 601A waiver is a very serious application. In most situations, and for most people, a 601 or 601A extreme hardship waiver is not a DIY project, right? You may want to do it yourself, but you want to get legal guidance as you're doing it. Consider an extreme hardship waiver a key that unlocks the door for you to get your green card or to get your visa to the US. If you are looking to open that door, you need that 601 or 601A waiver approved so that you can actually open the door and get your visa and get your green card. This is where getting adequate legal advice and having legal assistance through this process is going to be helpful for you. Whether it's coming up with strategies of how to prove your extreme hardship, what documentation that will be necessary based on your particular situation. If you are in a situation where you need the extreme hardship waiver, you do not want to guess on what to put in that folder. Let a legal strategist actually put together the packet for you. You saw the binder I dropped earlier. That is how thick most of my 601A and 601 waivers are, because we want to document every single evidence that we can put together to show that extreme hardship. If you do not want to guess, click the link in the description to book a green card strategy and case evaluation session with me, where we will discuss your extreme hardship factors and make sure that your hardship is strong enough for a winning extreme hardship waiver case. The second category of evidence is financial devastation. You want to show that you will suffer extreme financial hardship if your applicant relative leaves the US, okay? Again, the focus being on the qualifying relative. So financial, when it comes to the financials, you want to be able to show that they will actually suffer extreme hardship. The qualifying relative will suffer extreme hardship. So the fact that they are going to go from a 2-income household to a 1-income household may be seen as normal hardship. Anyone that their spouse leaves the US will go from 2 income to 1. For extreme financial hardship, we are talking about you are about to lose your home. You cannot pay for your basic needs. Your children will not be able to get their basic necessities because the financial breadwinner is now out of the picture, is now in another country, and will not be able to have the same level of income to support the household. So again, extreme hardship is the key here, not just what will happen if a spouse leaves the home. So when it comes to financial hardship, we want to look at what will happen. Realistically, what will happen if that household loses the applicant's income? So remember, when we're looking at financial hardship, we still need to look at it in 2 scenarios. One is if the qualifying relative stays in the US, what financial hardship would they face? Like I said, losing a house, losing their car, not being able to take care of their children because they're now losing this income that has been the main source of income for their household. Now, what happens if the qualifying relative decides to leave the US with the applicant? What financial hardship will they be able to face there? Because now you have to look at, will they be able to get a job in that country? Do they speak the language and that is required for them to get a job? So if it's a country that only speaks a specific language and at work you are still speaking that specific language and the qualifying relative does not speak the language, will they be able to find any work in that country that meets their current requirements? So let's say, for example, the qualifying relative is a registered nurse in the US. They only speak English. But now they have to move to a country that speaks a different language that they do not speak. Will they be able to effectively get the same job in that other country? In most situations, the answer to this question is a no, but you want to also document that. And we're going to talk about how to show what that country is going to be able to do or not do in the next category. In my office, one thing that I love to include for financial hardship is actually a financial breakdown, right? Breakdown, what are the income, what are the expenses currently for that household, right? If you can put together a financial budget of your household, like what a realistic month in your life looks like, how much are you paying for rent or your mortgage, utilities, all those things. And then how much of your income, household income, is coming from the qualifying relative and how much of the household income is coming from the applicant. That way you break it up so that the officer can actually see, oh wait, the applicant is making 90% of the income for the household. And if they were to leave the US, the qualifying relative will not be able to even afford rent. You want to give them a visual, and that's why a family household budget is one of the things that I like to include for the financial devastation, just to make it extremely clear to the officer of what that hardship is. And in my office, we usually try to put this together with your bills and, list out the bills, list out the income, pay stubs, things like that. The third category of evidence is the country conditions reports. So remember, in the first category, medical, we talked about, would the qualifying relative be able to get the same medical treatment in that other country? For the financials, would they be able to get the same jobs in that country? Would they even be able to get a job in that country? Well, the US government has a bunch of reports that you can use to help you with this. The first being their human rights report that they put out every single year. Unfortunately, under the current administration, they have not been putting them out, but I think the last one you can get is for 2023. Still good. So you can use that report. Also, the US Department of State has a travel advisory for each country. So if you look at the travel advisory for that country, is it at a level 4? And if it's at a level 4, that means it is not recommended for United States citizens to go to that country. You can use that report that the State Department is putting out for your benefit. Okay? Another thing you can look at is articles about violence against people that return after being outside of that country. So if someone has been in the US for 20 years and now they're returning, has there been a history or report of people being attacked because they were expats and are now coming back? You want to look at all of that. You want to look at the educational system in that country, especially if you will be forced to leave the US with your children and they will need education over there. Do they have the medical infrastructure to take care of the medical conditions that the qualifying relative has? Is it a country that has a robust mental health facilities and actually believe that mental health conditions are medical conditions? You will be surprised that there are countries that do not and still think that, it is not a legitimate medical condition. So you want to make sure that you are looking at those reports, and if it does apply, you want to print those off and include it in your binder. Okay, you want to include it with your packet because those are things that help the officer understand what the conditions are in that country and how those conditions will negatively impact the qualifying relative and cause them extreme hardship. The 601 waiver is one of my favorite things. Like I said before, it is a key that opens a locked door for many people. So I love this because I get to help someone go from not being able to get a visa, not being able to get a green card because they are barred, to now being able to get it. So I had a client many years ago, I've been doing this for 10 years now, many years ago, that came to me and just was not sure what to even include if they had extreme hardship. And I sat down with them, went through their entire medical history, financial history, and we were able to get their medical records. And when I say medical records, we got years of medical records to show that this medical condition is a chronic condition. It's not just that they had a slight headache one day, but it is a chronic condition that they have been dealing with over time. But they didn't see it as a chronic condition. Like, honey, you have had this going on for so long. You have had to have surgery to help you to manage the pain that you have been going through. But you do not see it as a chronic condition, but it is. So we were able to basically put together this evidence, put together the financials because they were all over the place, right? We were able to put together their financial, had them go file their tax return, because that's one of the things you want to include with the financials to show that you are being a good citizen, a good neighbor, I should say. So many years ago, I had a client come to me and they needed a 601A waiver for their spouse, but they did not think that they met the requirements because they just had some medical issues. They've had surgery here and there, and they didn't think it was enough. And I remember sitting down with her and going through what those medical issues are. She had back pain, because she had an accident a while ago that the back pain just never went away. It just lingered. And she has had multiple surgeries for this back pain. And she told me it wasn't a big deal. She has to see a doctor every few months because of this pain. And she needs to be constantly monitored to make sure it does not get any worse. And she truly believed that because she has been managing it all this time, that it was not a big deal. But guess what? It was a big deal. We were able to get all her years of medical records to show that this was not just a minor pain that she feels. Yes, she has gotten used to the pain always being there, but most people do not live with that pain. And one of the biggest things was her spouse drove her everywhere because she couldn't drive because of the pain. Her spouse made sure she got to her medical appointments, made sure she took her medication, did all of those things. Her spouse was the primary breadwinner because she could not work. She could not stand for a long period of time. But in her mind, oh, I've been dealing with this for so long, it's not a big deal. But we were able to get those documentation and show that, yes, it was a big deal. Yes, most people are not able to deal with this pain, or are not dealing with this pain on a regular basis. And she will suffer extreme hardship if her spouse was forced to leave the U.S. and she has to manage her medical condition herself. She now does not have the money to pay for her mortgage because her spouse is out of the U.S. So we were able to put this together, even though she thought she didn't have a case for extreme hardship, but we were able to really break it down for her. And although she didn't feel like it was extreme, it was extreme. She has just gotten used to it. So that's one of the things that that's one of the reasons that I love this, and one of the reasons that I tell people that sometimes you think you understand your hardship and you want to DIY it yourself, but you may need that additional legal professional, legal specialist that understands what USCIS is looking for to help you and guide you through the process. Now remember, if you are interested in getting that specialized assistance, please feel free to go to my website, lilylegal.com, click on contact us, and we can pick a date and time that works best for you for us to talk about your situation and figure out what your extreme hardship is, and figure out the factors that matter and what documentation you should be putting together for your waiver.